Most people don't realize it, but the first few hours after a crash can make or break your entire case. Say the wrong thing, miss the wrong step, and suddenly the insurance company's got all the leverage. I'm Doug Bernetti, personal injury attorney here in Florida, and I've been helping clients avoid these exact traps for over 30 years. So let me walk you through the 5 biggest mistakes I see every week and how you can steer clear of them starting today. Number 1, admitting fault at the scene. One of the biggest mistakes people make after a car accident is admitting fault at the scene, even when they're not actually responsible. I see this happen all the time. Someone steps out of the car, dazed, maybe a little shaken, and they say, "Oh, I'm sorry. Oh, I didn't see you." It's just human nature to want to diffuse the tension or be polite. But here's the issue. Those words can be used against you later. In Florida, under Florida Evidence Code Section 90.803, statements made by a party opponent, like you would be in that situation, can be introduced in court as evidence. That means even a simple apology might be twisted into an admission of liability by the insurance company or by the insurance company's lawyers. And the truth is, at that moment, you don't have the full picture. Maybe the other driver ran a red light. Maybe their brake lights weren't working. Maybe a third vehicle caused the crash and fled the scene. Maybe they were backing out of a parking place and they thought you should stop and see them when in fact they had the responsibility not to violate your right of way. But if you admit fault early on, you've planted a seed that could affect your entire case, even if the facts later prove you weren't responsible. So here's what you need to do instead. Check for injuries, call 911, exchange insurance information, and wait for the police. Be polite, but stick to the facts. Let the officers document the scene and avoid guessing or speculating about fault. It's not about being evasive, it's about protecting your rights until all the facts are clear. Mistake number 2, failing to seek immediate medical treatment. The second major mistake is not getting medical treatment right away. You might feel okay after the crash, just a little sore, but adrenaline can mask symptoms and many injuries don't show up for hours or sometimes even days. Under Florida no-fault law, your own insurance company pays for your initial medical bills through something called Personal Injury Protection, or PIP. But there's a catch. Florida Statute 627.736 says you only have 14 days from the date of the accident to get medical treatment if you want to use your PIP benefits. Miss that deadline and your insurer doesn't have to pay a dime. This isn't just about getting bills paid. It's also about protecting the value of your claim. I've had cases where someone waited 3 or 4 weeks to see a doctor, and the insurance company used that delay to argue that the injuries must have been minor or unrelated to the crash. Even if your injury seems small, go to urgent care, your primary care doctor, or a chiropractor. Tell them exactly what happened. The initial medical record becomes the foundation for your entire case. And if symptoms worsen later, that first visit proves you were taking your health seriously from day one. Mistake number 3, talking to the insurance company without legal guidance. This is a big one. If the insurance company calls you within a few days of the crash, and they will, you need to be careful. A lot of people think, I'll just tell them what happened. I've got nothing to hide. But that's not how this works. Insurance adjusters are trained professionals. They handle cases every day, all day. They're not calling to help you out. They're calling to gather information that limits what they'll have to pay you. You're not required to give a recorded statement to the other driver's insurance company. And even with your own insurer, you should know your rights before you say anything on the record. In the case of Cruz versus State Farm, a Florida appellate court looked at how vague or casual statements from the injured party were used to downplay the seriousness of their injuries. Phrases like, "I guess I'm okay," or "I don't think I need to go to the hospital," were later used against this person to justify a reduced payout. If you say something unclear like, "I'm feeling fine," or "I didn't see the other car," they'll file it away and use it later. That's why it's so important to speak with an attorney first, even if it's just to get clarity on what to say and what not to say. You can always reschedule that call with your insurance adjuster later, or let the lawyer handle it for you. Mistake number 4, posting about the accident on social media. This one gets overlooked all the time, especially by younger clients. You post a photo of your crumpled car on Instagram, or you make a quick, quote, "I'm okay," close quote, status update on Facebook. Seems harmless, right? Not to the insurance company. In the case of Nucci versus Target, the Florida courts made it clear that even a private social media post is fair game during a lawsuit if they're relevant to your injuries or emotional condition. If you're claiming serious back pain, but there's a smiling picture of you at the beach 2 days later, even if that photo was taken before the crash, it's going to cause you problems. I once had a case where a client posted a selfie of themselves in a gym 2 weeks after the wreck. He wasn't even there lifting weights, just for therapy. But the insurer used that photo to argue he couldn't be in that much pain. That one picture cost him credibility, and credibility is everything in these cases. So the rule is stay off social media while your case is active. Don't post, don't comment, and ask friends not to tag you. It's not about hiding anything. It's about not giving the defense ammunition they don't deserve. For example, you may have a post of yourself smiling at Disney World with your child. You look normal, you look fine. The defense will try to take that out of context, put it into evidence in front of a jury to show that you were fine. You were hanging out at Disney World having fun. Then you have to explain how painful that day was and how it increased your level of pain and you couldn't sleep that night. Very hard to come back after photos like that. So posting on social media is typically a no-no after an accident. Mistake number 5, waiting too long to get legal help. The last and maybe most damaging mistake is waiting too long to speak with an attorney. Some people think they'll handle it themselves, then call a lawyer only after the insurance company makes a terrible offer. But by then, a lot of damage may already be done. Florida statute of limitations for personal injury cases was updated in 2023. Under Section 95.11, you now only have 2 years to file a lawsuit after an accident. That clock starts ticking the moment the crash happens. 2 years sounds like a lot of time, but that time goes by very quickly. But even before that deadline, evidence can disappear. I had a case where we learned a security camera captured the whole incident, but the footage was deleted after 7 days. No one had asked for it in time. The client had come to me after that 7 days had ran. That kind of evidence can make or break a case. The earlier you involve a lawyer, the better your chances of preserving key evidence, building a strong claim, and avoiding the traps insurance companies set for people trying to go it alone. And most of us offer free consultation, so there's no downside to getting answers early. Legal guidance isn't about filing lawsuits. It's about protecting your recovery, your finances, and your peace of mind. Let's take a moment to recap the 5 biggest mistakes people make after a car accident in Florida. Admitting fault too soon, even when they don't have the full picture. Skipping or delaying medical treatment, which puts both their health and their case at risk. Talking to insurance adjusters without understanding how their words will be used. Posting on social media and unintentionally giving the insurance company ammunition. And finally, waiting too long to get legal help. Missing opportunities to protect crucial evidence and preserve their claim. Each one of these mistakes is preventable, and just understanding them puts you miles ahead of most people who go through this process unprepared. But here's the thing. Avoiding these 5 mistakes isn't enough on its own. The next major hurdle is how you handle the insurance company when they come back with a lowball offer, because they will. That's why in the next video, I'm going to walk you through 5 tips to stop insurance companies from lowballing you after a car accident. I'll show you exactly how to document your injuries, when to negotiate, and how to respond when their offer doesn't even cover your bills. If you've been in an accident and you're serious about protecting your case, you need to see that next. Thanks for watching. I hope this gave you some clarity, some confidence, and a better sense of what to do next. See you over there.